own submissions, which are before my lodge, in fact gives you the numbers of 3 categories of those who are tainted. One, and this is in the note, my lords. So your lordships don't have to be inconvenienced, my lords. This is in my note, page 4. Page 4 now. It's a very brief note, my lords. It just extracts data from the CBI's own system.
It's not going to be possible to take notes like this.
Very well, my lords. This is also filed, my lords.
We are noting down whatever is there.
Yes.
But that
It's volume 6, my lords. It's also been filed. It's been filed by the CBI. This note is also filed. I just thought for my lords' convenience. And the point here is very simply this, my lords. Volume 6. The CBI says, now please see, my lords, when it comes to assistant teachers, which is the candidates who are untainted, who I represent. My lords, this is paragraph 8, my lords, page 4. Paragraph 8 in my note, page 4. This is taken from the CBI submission. I have only reproduced it. Now, 3 lakh candidates take the exam for teachers, assistant teachers, my lords. 3 lakh candidates. 20 lakh is group C and D. 3 lakh is this. Now, please see the irregularities or the tainting. And I want to show my lords this numbers because please see the minuscule minority, which is this number. Assistant teacher, my lords, have this. Appointments after expiry, 183. Classes 9 and 10. And classes 11 and 12, my lords, have this 39. Candidates beyond the panel or waitlist, 110 and 18. Now please see the total instances of manipulation. This is on 3 lakh candidates. Please see, my lords. Assistant teachers, this is line 2, 952, 9 and 10. And 11 and 12 is 907. And the ones who submit blank OMAs is 22 and 15. So in each category, my lords, this is 8% and 10% of the total number of candidates who take these exams. Now your lordships in Vanshika, now, my lords, I just extracted a case which is part of the compilation for my lords' convenience. The High Court refuses to accept your lordship's jurisprudence in Vanshika Yadav, my lords. And Vanshika Yadav, page 5, is extremely important because my lords took the trouble of making 2 points in Vanshika. That at the first level, my lords, has this para 10 of the note, my lords. This is the last page. And this is in volume 7 of a compilation of judgments which my lords have. I just extracted.
Yes.
Your lordships do 2 things in Vanshika. One, you take the trouble of segregating the tainted from the untainted.
Yes.
And please note that tainted vis-a-vis the teachers is a minuscule minority. I've shown that from the CBI's numbers, my lords.
Yes.
Then your lordships make a second point in Vanshika Yadav. That even when the CBI investigation is underway, solely because there are irregularities of a nature, you cannot stop the process of segregation and terminate everyone. Your lordships have been confronted with cases similar to this because over in this country, recruitment to government jobs, teaching positions, overwhelming numbers of candidates apply, lakhs and lakhs apply for jobs in the police, jobs in teaching, jobs as engineers, and therefore there tends to be some manipulation across the board. But when the manipulation is of a nature of twofold, minuscule minority as well as the ability to segregate the tainted from the untainted, which our investigating agency is doing, then your lordships responded with Vanshika by saying the response has to be proportionate. That is the language your lordships use, that the response to a situation like this must be proportionate. The High Court, by refusing to segregate and by terminating en masse, even untainted like ourselves, who have not been heard, my lord. This is the other part of the story. We were never given notice, we were not heard. We have been teaching faithfully with due diligence over the last 6 years. There is not a blemish on how we've taken the exam or how we have cleared the exam. The High Court refuses to reflect on the jurisprudence laid down by my lords in Vanshika. And that is the element that I have compiled here on this page, my lords, for my lords' convenience. And my lords, very importantly, my lords, your lordships were troubled by the destruction of the owners. So I'd like to deal with that very briefly and head on. It's on the same page. That this is paragraph 12, my lords. And I'll end with this because this has troubled my lord, the Chief Justice. My lords, Rule 21, please see paragraph 12, I've extracted the rule. Rule 21 of the West Bengal Central School Service Commission, selection for appointment. And this is part of the volume of rules and statutes, which is part of my lordship's compilations. Service Commission selection for appointment to the post of teachers for classes 9 and 10 and 11 and 12. These rules are specific per class. Very categorically say this, and I've extracted this. The written answer scripts, OMRs of examinations, shall be destroyed by the Commission after 1 year from the date of publication of the panel. It is now, at the time the High Court is seized, it is many years after the publication of the panel. In fact, I think it's 6 years after the publication of the panel. So, there was not a concerted conspiracy. The rules and this rule in specific has been followed. For this, untainted candidates like myself, my lords, should not suffer. The investigation by the CBI, 3 supplementary charge sheets later, their submissions which they filed before my lords, all indicate that one, they have been able to segregate the tainted from the untainted, and if anything remains in terms of filing of the charge sheets, that is a process of enforcement of criminal justice, and that will happen. But for that, a disproportionate response is what the learned High Court does, my lords, which is en masse termination. That violates.
I item number 30. Item number 33. I just take 2 minutes of your lordship's time. Lord, would your lordship turn to page paragraph 240 of the impugned order? Lord, there is a table there at paragraph 240 of the impugned order.
Yes.
Lord, that paragraph gives the percentages of irregularity. It ranges from 8.5, goes up to 44.87. Lord, I am appearing for untainted candidates in Group C and Group D. Lord, the maximum is 44.87. Paragraph 242, the High Court says, Lord, there might be further possibility of further candidates, numbers increasing, but that has not happened. So the maximum your lordship would have is 44.87%. Lord, I am now citing Johnny Bentham, Lord, the greatest good of the greatest number is the object of law. Lord, here, you're being invited to cull the entire number of sheep, cull them, just because there are a minority of wolves. Lord, when it doesn't exceed 50%, Lord, this culling cannot be done. Please don't throw the baby with the bathwater. Lord, if your lordship then turns to paragraph 243 at the bottom of the page, last sentence. Bona fide candidates who had participated in the selection process deserved a lot better and far more humane treatment. Lord, this is what I would invite my lords to do. Untainted candidates deserve a far more humane treatment than mass culling. I am obliged.
Lord, my case is a little unique, Lord. Lordship may kindly take up SLP number 16249. And I'll be not very brief, I'll just show 2 pages, Lord. 16249, my lord. 16249.
Yes, please.
Now, my lord, your lordship can take it from me that I am one of the 33 candidates against whom no wrongdoing was established. That is, my lord, at page 460, dealt with 464 of my brief. I am not troubling my lord, my lord. I am one of the candidates against whom no wrongdoing has been established so far. Number one. Number two, my lord, when the matter was before my lords by the order of 9th of November 23, your lordships were pleased to remand back, my lord, 19 petitions to the Calcutta High Court. My matter, my lord, was not one of the 19. My matter was not, my lord, remanded back to the High Court. So I was not heard before your lordships, my lord, in this court. Number three, my lord, the High Court on remand, my lord, directed notices to be issued. Notice was issued to me, my lord, in December 2023. Very next month, my lord, in January 24, my lord, I approached the Calcutta High Court and filed an impeachment. Now, my lord, kindly see the impugned judgment. I will just show 2 pages and I am done, my lord. Page 157, my lord. Page 157. And para 124, my lord.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted in 21-22. This is very important. I am so sorry, my lord. Page 157, para 124. I am so sorry, my lord. 157 in my brief, my lord, para 124.
You are referring to the internal page.
My lord, for the common page. So, my lord, it's a common one volume. I am so sorry, my lord.
Paragraph number? When I'm looking at the question file, I'm looking at the first line.
Let's see, read from my.
Yes. Yes.
Lordship has it, my lord?
Yes.
I'll just read it again, my lord, quickly. Page 157, page para 124.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted, lordship may mark, instituted in 2021-22 and the appeals arising out of the orders passed in such writ petitions. Then, my lord, para 125. Consequently, we have the jurisdiction to hear and dispose of appeals arising out of the orders passed in the 4 categories of matters in writ petitions filed in 2021-22, contours of our jurisdiction to decide the writ petitions and appeals emanating out of orders passed in such writ petitions having been adverted to, we shall proceed to decide such matters which fall within our parameters. So what was heard, what was remanded by the Supreme Court was not, my lord, my matter. What was heard by the High Court, my lord, is not my matter because my writ petition was instituted in 2023 and not 21-22. And now your lordship may kindly come to page 279. 279. 279, right in the beginning, my lord, in the first very line of the page. Lordship may kindly mark WPA 3846 of 2023. The para starts, my lord, from, my lord, page 275 conclusion, para, my lord, 364, 365.
Para 279.
Page 269. Page
Number.
This is block 365, 366, 366. Para 366 at 279, just lordship may mark WPA 3846, which is my writ petition. WPA 3846 of 2023, and below that para 280, the last line, after below all the narrations of these WPAs are over.
Which paragraph are you left?
I'm so sorry, Lord, page 279. I'm so sorry. Very first line, my lord, of page 279.
Oh, list of cases.
Para 366, page
Yes.
279, the first, the second, my lord, WPA 3846.
3846. Yes.
Lordship has it, my lord, 3846 of 2023, and at the next page, after the narration of all these listing, along with all connected applications are released from the list. So my matter, my lord, was specifically released from the list. Then, my lord, the next paragraph, 367. So far as the appeals are concerned, all appeals emanating out of orders passed by the learned single judge in writ petitions filed in 2021.
Last one.
I'm so sorry.
Yeah, you will not be covered by the judge.
That's right. That is my only point, my lord. My matter was released. My matter was not before the Supreme Court.
And why you here?
Because I am affected, my lord, by the direction of page 272, I have been thrown out. When my matter is pending before the High Court. You know, this is really disturbing. Page 272, Roman 2. All appointments granted in the selection process involved being violative of 14 and 16 are declared null and void. My matter is still pending, my lord, before the High Court. I have not been heard. Yes, no, that clarification is all that I am asking.
1 minute, please. You have to read 1 and 2 together.
Yes.
Read 1.
Writ petitions appearing in the monthly list of March 24 of this bench, which are not filed and numbered in the years 21-22, are released from the list due to lack of jurisdiction determination. I do not fault, my lord. All I want is a clarification that, my lord, I cannot be, my lord, the effect of this order cannot, my lord, I can't be affected by this order.
But in this of this bench, you are not filed. The number in the year will be released for. No, this will apply to the requisitions which are disposed of.
Therefore, all that I am saying is that I cannot be terminated on the basis of this order. That's all that I am saying. That clarification is all that I am wanting, my lord. Nothing more. I am not entering into this dispute at all.
Who's the parent, state of West Bengal, please, on this point, just inform us. No, later on in your turn.
That's all, my lord.
The High Court website shows your matter is pending. The High Court website must be showing your matter is still pending.
It's still pending, yes. But that clarification, I cannot be dismissed, my lord, on the basis of this direction.
How can it be?
Lord, the state has to clarify.
State has to clarify more application clarification to the court. We get that.
Lord,
Instead of running over here, you should have moved an application asking clarification in regard to paragraph number 2. With reference to the paragraph, it says such and such are released from this list.
Lord, I am told that they will not entertain any such applications. All, my lord, result of this impugned judgment is all, my lord, appointing.
Okay, fine. Next case. Next
Group
one.
IPF for group.
May I mention, present, my lords, if I may, just one at a time, my lords. My lords, I am limiting myself.
I just want
My lords,
to
I only take 2 minutes.
How can we away this? We cannot have this.
I beg the
May I?
No, please don't.
SSC 10317.
You also argued.
No, I have not argued, my lords. I have not
You are
present.
there.
I was not there, my lords. I am appearing for the first time before my lords.
Okay, please.
So may I only take 5 minutes of my lord's time to submit on something which has not been addressed before this honorable court? I will not repeat anything, my lords. I am limiting my submissions to the aspect of electronic evidence. I am in 34.63 for Group D, tainted, my lords.
What are you saying on electronic evidence?
My lords, repeatedly the issues with respect to the hard disks have been mentioned and about this provision of a 65B certificate or not. But the crux of the issue really goes beyond that to the provenance, and that decides every aspect in terms of the acceptance or otherwise of the evidence. My lords, and this is based on 2 judgments that have come from this honorable court and
They are not.
operated.
Oh, please, experience.
I am not going
Last
to.
1 minute, please. We are not concerned over here with the evidence, sir.
Yes, ma'am.
Neither are we concerned with Arnav versus Rashid or Navjot sir.
Yes. I am not going into Anwar versus Bashir or Arjun Pandit Rao to argue about the sustainability or otherwise of the electronic evidence, my lord. I am only limiting my submission to whether the so-called category of tainted can even be mentioned as such based on the evidence that the CBI is relying on today at this juncture. And I am relying on the Mohammed Arif case of this Honorable Court, which talks about the first level that has to be crossed by the prosecution will have to be whether that is not prosecution, my lord, my apologies, for the state would be whether this is even sustainable for removing these persons from their appointments or not. The first foremost, my lords, is that these are petitioners who have not been given inspection. They have been unilaterally categorized as tainted on the basis of the Pankaj Bansal seizures. If my lord sees, there is an assumption that that an OMR sheet which has been scanned cannot have errors. There is sufficient evidence to show, and this is something which has happened in terms of improvement in technology itself, my lords, which says that where OMR sheets earlier contained alphabets and there was misreading and errors in terms of the reading of those OMR sheets, now therefore it has been moved to multiple choice questions where the technology that is being used is merely to read a marking which is just filling in a round, my lords, instead of entering alphabets. Therefore, my first submission, my lords, is an assumption that an OMR sheet scan is valid to decide whether a person is tainted or not in itself would be specious and would be unfounded. The second aspect that I am submitting is, today there is no evidence before my lords to categorize anybody as tainted, because what is being relied on, let us assume, my lords, there are three sets of electronic records that have been recovered. One from SSC, where CBI has clearly said that the scanned documents are no longer available with SSC, or that they have other rights. Therefore, we are left with two other seizures, one from Pankaj Bansal, where supposedly a 65B certificate is given, and one from DataScan, whose very existence in the entire process is not substantiated. Assuming they have some copy, the provenance of the copy being original is not established. In fact, the so-called 65B certificate of Pankaj Bansal clearly shows that he only has external devices which are copies. And the 65B certificate at best reads like a seizure mahazar and not a 65B certificate. Therefore, I only want to draw my lord's attention to two aspects.
Item 34.5.
May I only draw my attention to para 33 of Arjun Pandit Rao and 25, only to say that one, what is required for a 65B is for the computer which originally had the data to be proven to be working properly and to have data input in the ordinary course of business.
Please, that's not correct. What it means, 65B only requires is the person who's producing that data should say that this data from the computer as originally he had uploaded it. And that particular person is in a position because he's not an accused.
In fact, in page 25 of Arjun Pandit Rao, the court distinguishes between original and a copy, also point to
original and copy.
65B here.
Original and copy.
Only one aspect.
Original and copy also there is a little, let me put it. Suppose you see the CD.
Yes.
That's the original for you.
It
But
is
the
not.
CD may have been taken from another CD, or it may have been taken from X, Y, and Z. So when you give that, please. So that's a problem with electronic evidence. That's a problem because it can be transferred from one source to the other source, to the third source. And if you look at the definition in the Information Technology Act, you'll come to know each are treated as original.
No, I am obliged for this.
I am in section 34.
Let me just take 1 minute.
Item 34.5.
What my lord said leads to what I was submitting, my lord, which is that the province in terms of where
strictly going by.
made. Where the external
We are not strictly going by 65D. These are decisions.
But in which case then the category shown as tainted cannot be treated as tainted as our submission.
Plus, item 34, Saddam Hussein's petition, I have 30 seconds, Mullah.
Okay, yes, sir.
I have 30 seconds, Mullah. This is Saddam Hussein's petition.
For ones who are joining us to video conferencing, you'll have to wait after the physical, after we have heard the Taxi or physical.
I'm appearing in SLP 10617 for the Group D candidates. I want to draw your attention first to para 340 of the judgment.
Yes.
May I be clear? It should be page 269 on the machine.
Yes.
In the facts of the present case, the writ petitioners had approached the writ court primarily to secure employment for themselves.
Yes.
To secure employment for themselves. Please mark this. Orders had been passed in the writ petitions. An investigation had been carried out by the CBI which disclosed the scam of an epic proportion. Order of the investigation to CBI had not been interfered by the Supreme Court. This is palpably wrong because in para 9 they say there is no cognitive evidence, please go back for the investigation. CBI had registered 4 cases, 5 charge sheets and supplementary charge sheets therein. State has taken into consideration the subsequent events and at the level of the cabinet decided to create supernumerary posts for persons who have been granted appointments illegally. Though, therefore, we are obligated to take into consideration the subsequent events more the relief that the parties are entitled to. We have to provide substantial justice between the parties, take cognizance of the subsequent event and grant relief. Now, if you are to look into this aspect, not all the candidates are tainted, but you cancel the entire selection process which has taken place. We were appointed in 2018, we continued in service, and our services were terminated in 2023 based on premises which the court says is yet to be established in your judgment of 2011. You remand it back. Say, please find out the causes. None of that has gone into. So therefore, if those of us who have been appointed, we have continued in service, I respectfully submit if there is no prayer, then the washing of our appointments is contrary to law.
I LP civil number 10545. My case is little different. I appear for 2 of the assistant teachers in the 11th and 12th nutrition. There are altogether 74 posts which were available. My case is, that there is a mismatch of marks, but in any case, even if we go by the OMR sheets, I still qualify. I am above the cutoff. My Lord, may kindly see my written submission.
That may not work.
What I am, I just make. I have not been put in the rank jump. I am not there, and my name doesn't find mention in the rank jump. But the only thing is, of course,
once you are in dispatch marks, you are in the.
But may I just say this, even if we have to go by the OMR sheets, even if I have to go by the OMR sheets, then also I qualify. And the onus cannot be on me. It would have been a different. Because it would have been a different. Why would I indulge in something?
Dispatch of marks. But
my only submission, if I have gained something,
we only don't know what has happened to the original.
I asked a question to myself. If I have to gain something, but even in the mismatch, if I qualify, why would I? I was not even heard in the High Court.
They have already argued that.
Item 34.25, item 34.25 and item 34.92. These, my lords, candidates of Group C and Group D, they are absolutely untainted. They have got, my lords, no misrepresentation, no fraud, no forgery, nothing. They are not actually connected in any way, my lords, with the OMR sheets, number 1. Number 2, my lords, the petitions were filed, my lords, in the High Court challenging the waiting panel. My lords, at page, my lords, in item 34.25, at page 364 is the prayer. The prayer is the waiting panel which has been issued in 2019 is not in accordance with the rules, and therefore they should be set aside. It is not actually the 2017 panel, my lords, which have been published. There was no prayer at all. Actually, the 2017 panel should be quashed. All that they requested was that the 2018 panel should be abolished. Number two, 44 my lords vacancies which were actually there, that should be filled from the reserve panel. It is not their case that none of the petitioners have ever committed any fraud or any irregularity insofar as their appointments are concerned. In the light of these facts, my lords, I submit, my lords, 3 points for my lords' consideration. 1. We were not at all parties to the petition. We were not put to notice at all. No notice was issued by the High Court to us at any point of time. Suddenly, one fine morning, my lords, the entire appointments are quashed. Number 1. Number 2. My lords, in so far as our role is concerned, we have on our own merit, my lords, we have gone through and we have been selected from 2018 onwards, my lords, we have been working. Almost for 6 years we have worked now. There is no blemish found in our, my lords, work. Number 2, my lords, the confirmation has also taken place. Now today, if my lords, you have to remove us after the probation period is over and you are wanting to terminate us without even simplest of a show cause notice to us, my lords, it's completely illegal. This is number 2. Number 3rd point, my lords, my respectful consideration is, my lords have held, where my lords, the untainted candidates, my lords, was sought to be, my lords, set aside. Their economic background, their systematic, my lords, evaluation, my lords, in their service, then, my lords, the livelihood which will be affected by virtue of this order, my lords, all will have to be taken into consideration. That's what my lords have laid down, my lords, in 2013-14 SSC, my lords, 494. 2013, volume 14, SSC 494, paras 22 to 30, my lords. Yes, paras 22 to 30, they have, my lords, gone into this issue. Untainted candidates cannot be clubbed with the tainted candidates for a number of factors. The court ought to take a sympathetic consideration insofar as untainted candidates are concerned for the simple reason that they have worked for a number of years without any blemish. Number 2, their livelihood is being taken away. Their economic background has to be taken into consideration. They may become overlaid by virtue of this, my lords, question. Today, my lords, the petitioners, my lords, or my lords, thrown out en masse according to this judgment, and we will not be in a position to compete in any of the examination because we have become overage as of now. Despite the fact, my lords, we are in no way, my lords, connected with. My lords, these are the 3 simple submissions, my lords. I will, my lords, put a small note, my lords.
They made us only 1 minute, my lord. I won't take more than even 1 minute. See, the only thing I am appearing in 34 5.5.
Not that may I have a minute.
Untainted, can I find my answer?
Because I am appearing for those persons who are in the wait list. Wait list candidate. Now we have not been in the job throughout from 9
The panel after expiry of 1 year.
Yes, no, but the people have been taken, in the services, over us, who were much below, who were
on this side, no?
No, I'm not a petitioner. So, what I am saying in this matter, as now, there are identification of all those people who have been irregularly appointed. There are, the identification.
Should be appointed.
No, so what I just want to convey, only one thing, that now,
They are more optimistic.
another one, what I am just saying, now at this second, after 8 years of, being out and not getting job, now it's over, we have become overaged, and now it has become difficult, and all those people who stand for the irregularities, they are in the service, they are going ahead with
That's all.
A very small point. It is to assist my lords also to identify tainted from untainted. It is there in CBI's own affidavit. Those who are the submissions filed here, would my lords please turn, just can you allow us please? My lords may see page number, my lord, in volume number 6 of written submissions filed by CBI. CBI gives the number of the cases, gives the total candidates, my lords, in
We have got this list.
So, my lords, I am saying I come in the category which was appointed in the 8th counselling round of the waiting list, but does not appear.
I understood this argument, but there is a counter argument.